All right, good morning, everyone. This is case CR 22-21-1623, State versus Chad Daybell. This is the time we have scheduled for multiple hearings this morning. A few preliminary housekeeping matters to go through. We do have the court reporter here today, as well as recording this on the court's audio system through the FTR system. Because we are relying on the audio recordings for distribution to the media, I would ask that counsel or those addressing the court make sure to speak clearly into the microphones. So in lieu of standing or moving around for today's arguments, if we could make sure those microphones are being utilized to pick up the recording as well, and the court reporter will get the transcript as well. In addition, the court's issued a new administrative order that governs courtroom conduct in this case. As it relates to the general public, I would reiterate what's mentioned in that order, that cell phones for this hearing must be silenced or turned off at all times while in the courtroom. If a cell phone or other electronic device rings or beeps or is found to be in use during court that's inconsistent with this order, it would be confiscated by the marshal, and no one may talk on a phone in the courtroom during the hearings. Other electronic devices here may be used only for note-taking, but shall not in any way be used to record or transmit any sounds or images from this courtroom. And if any electronic device is capable of recording or transmitting sounds or images, those functions should not be activated while the electronic device is in the courtroom, and violation of that rule may also result in confiscation of the device. So the court would ask that all in attendance comply with that order. In terms of what's scheduled this morning, the court's got motions filed by a non-party movement regarding unsealing of records. We've scheduled that for argument today on a hearing at 9 o'clock. The court's then got further substantive motions with counsel that would be slated to commence at 9:30. And those include multiple motions that we'll get to. The court intends to take a brief break to understanding that counsel wishes to meet with the court before we start those substantive motions at 9:30. So that'll be the schedule moving forward. At this time then, the court is in receipt of motions filed by a non-party movement, Lori Hellis, and has requested a hearing pursuant to Idaho Court Administrative Rule 32. Court's received a motion filed September 3rd, along with a declaration and memorandum in support, and a supplemental declaration or memorandum that was filed on September 14th. So we'll take that matter up first. Ms. Ellis, if you'd like to come forward, please, I would ask that you stand at the podium and you can present argument in support of your motions.
Thank you, Your Honor. Your Honor, I am a retired criminal attorney. I'm an author, and as such, I've asked the court to recognize me as an interested party in the case pursuant to ICAR 32. Your Honor, the court has my, sorry, I'm a little rusty. I haven't done this in a while. The court has my memorandum and my supplemental memorandum, so I won't go any further into those things. But, Your Honor, I do have a few preliminary remarks. Anybody who remembers their 8th grade civics can tell you that our founding fathers thought highly of checks and balances. And although we often talk about the 3 branches of government, our founding fathers didn't limit their intent to build in checks and balances to that matrix. One of the essential checks and balances is the First Amendment and the right of the public to access to their government. And in order to facilitate that, we have the First Amendment protections again for free speech and for freedom of the press. Nowhere is that more essential than in the criminal justice system, where liberty, and in this case, life, is on the line. In a government that is by the people and for the people, it is the responsibility of the electorate to provide oversight to their government. That's not possible without the First Amendment. Your Honor, there is no exception to the First Amendment for protection of elected officials, even in a small town. Your Honor, I did want to point out that the court in State v. Clapp, which is 168 Idaho 67, Idaho Court of Appeals in 2020, the court points out that a party seeking to seal the record bears the burden of demonstrating that the party's privacy interest predominates over the public's interest in disclosure. That's not possible if the court is not following the law as it applies to sealing documents. Unfortunately, up until the court's last order, there is no indication that the court has followed the ICAR 32 procedures outlined in the statute.
Let me ask you a question about that then. The court issued an order January 4th, 2021, where the parties requested that a hearing and records be sealed. The court specifically indicated we went through that procedure of ICAR 32, and for the factors in ICAR 32, I denied the motion to seal, and that's the procedure I followed throughout this case in sealing. So why do you say there's no indication I followed the rule when there's a previous order where I expressly cite to the rule?
I agree that in that particular case, in that particular order, the court did go through those findings, but there are many, many orders in this case where there's perhaps you did, Your Honor, but there's no way of knowing that because all of the documents are sealed. I believe, Your Honor, that the court has already validated my argument with your last order in this case. The last order very carefully outlined what had happened, the court's reasoning for concerns, and the court's identifying the necessity for sealing particular parts of the record, and then redacted an entire paragraph of sensitive information, rightly so. And it's clear from that last order that the court has changed your procedures or your policy when it comes to those orders, because that order was not sealed, unlike all the orders having to do with Ms. Vallo's previous mental health issues and with the court's previous rulings on those. So it seems to me that the court has already conceded that the procedure that you followed in this most recent order is the proper one. My question is, what happens to the documents and the proceedings that have been sealed for the last 2 years? The public does have a right to know why documents are sealed, and the court very appropriately outlined the reason why those documents were sealed in the most recent order. There was certainly no way to find fault with that order. Going back, though, there are probably at least 4 or 5 entries in the court's database that just say order. There's a motion, there's a seal, there's an order to seal, and then there's an order. There's no way for anyone in the public to know what that order's about. Is that an order that was properly sealed? Or is that an order that was sealed out of convenience or out of protection or out of some other motivation? The court has denied the public's right to oversee their government and their elected officials by the wholesale sealing of these documents.
What do you mean by wholesale?
Your Honor, I mean that the law requires that the court make written findings on the record, as you did in your last order, as to why the documents need to be sealed.
What does wholesale mean to you? Because to me, that would mean I'm just sealing vast parts of the case. And the court has sealed many documents in this case related to specific exemptions under ICAR 32G, specifically G10 and G26. And there's reasons for doing that, but what do you mean by wholesale?
Well, Your Honor, in my experience as a defense attorney, I've never seen a case where nearly half of the documents in the case are sealed.
Okay. Did you practice in a jurisdiction where ICAR 32 governed the sealing of records?
No, Your Honor, I practiced in a jurisdiction with a very similar statute.
Okay.
I can only look at what the public sees, and what the public sees is that there are a great number of documents in this case that have been sealed, and there is absolutely no indication from the official record why they were sealed. There's no way to know. I don't know whether those documents were inappropriately sealed or not, and all I can say is that I have been told that there are things in those documents that are not do not fall under ICAR 32. That's hearsay.
Your Honor, I'm going to object to that. I think we're getting into counsel attempting to testify or insert facts.
Well, now I'm thinking of the posture of where we are, Ms. Blake, whether or not the state has a right. The state's certainly an interested party, and so considering the nature of the proceedings and that this is a non-party movement, the court will allow the parties here to interject with objections if appropriate, and I will sustain that objection, Ms. Blake. So to the extent you're arguing hearsay, that's stricken. You can present your own argument, Ms. Ellis.
Your Honor, my point has been that there is no way to know whether the court followed the appropriate procedures. There is no way to know whether or not the material that was sealed was appropriately sealed under ICAR 32, because the court did not make written findings for every one of those orders. Now, I concede that the January 20th order was different, that you did make those findings, but they weren't made in many different orders. I'd have to go back through the record. I outlined every one of those in my motion, every one of those sealed documents. And I don't know of anybody who wouldn't say, that's an extraordinary amount of sealed documents, even for a case dealing with a defendant's competency. I hope I'm wrong, but there's no way for the general public, the citizenry of the state of Idaho, of which I am a resident, there is no way for us to know whether or not those documents were appropriately sealed. I believe the court has, by your actions in the most recent order, conceded that perhaps those procedures were not followed before. My question now is, what do we do with the last 2 years' worth of sealed documents?
Let me ask you a question about your supplemental memorandum you filed. You have a statement in there and say, quote, "We find the court has abused his discretion frequently and regularly." Who is the "we" that you are referring to there?
The royal we.
Okay. And was there some sort of appellate procedure where a determination was made where the "we" found that I've already abused my discretion before we've even had a hearing on this?
No, it's my observation.
Okay. All right. And as to your question about further review of prior matters that have been sealed in the case, the court is happy to look through those in the context of Rule 32, ICAR, to determine whether or not the procedures were properly followed, and I intend to do that based on your motion.
I hope so, Your Honor. That's all I've asked the court to do, is to reconsider the decisions going back and looking at those documents to determine whether or not appropriate findings were made and whether or not it was appropriate to seal them, or whether there was a less intrusive, a less restrictive way of handling those documents, which would be, as the court did in your last order, redaction. So I'm asking the court to re-examine those and determine whether or not there's a less restrictive way to handle those sealed documents. And I realize that that puts a burden on the court and the court staff in a small jurisdiction. But even in this case, I don't think that we're excused from doing things the proper way and making sure that the citizens of the state have the right to oversee their government proceedings. So I'm asking the court to take a look at those back documents and determine whether or not there's a less restrictive way to treat those documents rather than sealing everything.
All right, fair enough. I understand the request, and I think under the rule you do have standing to bring that request on behalf of the citizenry, and the court does intend to go back through the prior sealed filings in the case to determine whether or not ICAR 32 has been complied with, and the court would issue a written ruling upon review of those documents. There are other interested parties here that have been served. Let me start with the state. Does the state intend to make any comments at this hearing?
I think just briefly, Your Honor.
Go ahead, Ms. Blake.
The state did...
For the record, Lindsay Blake on behalf of the state. I haven't called the parties formally for the substantive motions, so I'll just note who's speaking here.
Thank you, Your Honor. As the court and the parties are aware, the state has filed just a brief response to this request. I think the only thing that the state would point out or kind of distinguish is under ICAR 32, we're dealing with two separate subsections here, both G and I. And I think the one that's really an issue is I. When you look at ICAR-G, that is a very different subsection. There is no requirement that the court make specific findings or that a hearing be held or any indication that any interested party can intervene in that. Under G, it's just very clear these documents are sealed, and then there is a procedure outlined in H for someone to request copies of that, but it appears to be more in line with our public records request that we have in Title 74. ICAR-I, on the other hand, is a little bit different, and it does allow for an interested party to intervene, which the court has allowed Ms. Hellis to do. But I think as we've gone through the argument this morning and even looking at the prior filings, there's kind of some overlap and confusion between G and I. So the state's position is Ms. Hellis would not have any standing as to any document sealed pursuant to ICAR-G, because that simply isn't called for or allowed under the statute. So I think we're really looking at any documents that were sealed pursuant to, or proceedings sealed pursuant to ICAR-I, and I think the standing would be appropriate under any that are sealed under I. So the state would just make that clarification, because I think with all the filings, those kind of overlapped at times, and they're very different requirements and procedures regarding those.
All right, I appreciate the comments, Ms. Blake, and I do agree with your analysis of the rule that G clearly is just records exempt from disclosure. I, however, is the discretionary function that may require a hearing. So thank you for the comments. Any comments on behalf of the defense? Mr. Pryor?
None at this time, Judge.
Thank you. The court would note also there were other interested parties that had been served. Once the court identified those, is there anyone else that is an interested party identified on the certificate of service that would like to make a comment on this issue today? All right. Anything else, Ms. Ellis? If not, we'll consider the matter submitted.
No, Your Honor, I appreciate your courtesies.
All right. That will conclude the hearing on that issue then. Counsel, I understand that you wanted to meet with the court before moving forward with the substantive motions. If we could take a brief sidebar in chambers, then the court will talk to counsel for a moment, and then we'll get started with the rest of the hearings. Okay, we're back on the record. Mr. Fuller, are you ready? Thank you. KCR 2221-1623, State versus Chad Daybell. Representing the defendant, Mr. Daybell, who's here present, is Mr. Pryor. Representing the prosecution today on different motions are Lindsay Blake, Tanya Rawlings, Rob Wood, and Rachel Smith. This is the time we have set for hearing on multiple motions. We met in chambers prior to starting this hearing to discuss the order of the proceedings. There's been a request made that we consider the motion to continue trial first. I understand that Ms. Rawlings would be arguing on behalf of the state, and of course Mr. Pryor for the defense. So the court would note it has received a motion to continue the trial that was filed by the defense in this case on September 27th. I've reviewed and considered the motion. The state's filed a response, which is in some terms a non-objection, but I guess we'll get more to the heart of that during argument. At this time then, based on the discussions in chambers, I understood the state wanted to initially address its argument whether or not there should be a stay in effect, and because that could affect proceedings going forward this morning. In this particular case, the court would like to first just hear briefly any argument as to whether or not a stay should be in effect in this case. And once that argument's been made, I'll allow response from Mr. Pryor. Subsequent to that, then we'll get into the merits of the motion, assuming we go forward on the motion to continue. So, Ms. Rawlings, if you'd like to present the court with the argument regarding the state's position on a stay.
Thank you, Your Honor. It is the state's request that the court consider entering a temporary stay in Mr. Daybell's case. The state recognizes the necessity of the stay that was entered into in the co-defendant Vallow Daybell's case. And in line with defendant Daybell's request to continue, the state is asking for the court to enter a temporary stay to allow time to address the issues in Ms. Vallow Daybell's case and to avoid relitigating some of the same issues. As mentioned, there are pending motions and requests for the court to review certain matters. For example, the bill of particulars. There's some other issues that are overlapping that we think by staying Mr. Daybell's case would avoid potential relitigation or potentially re-arguing it. In addition, Your Honor, I think that in line with the defendant's request for a continuance and a status conference to be held in January, that would allow time to go through the necessary steps to resolve the issues pending in Ms. Vallow Daybell's case and coincide with the defendant's request for the continuance, allowing a new trial date to be, allowing a scheduling conference in effect to be held in January and then a new trial date. And potentially a scheduling conference for the remaining matters that need to be argued.
All right, thank you, Ms. Rawlings. Mr. Pryor, what's your response as to whether or not
Can I
a...
approach the lectern?
Yes.
Judge, one of the concerns that I have in regards to these cases is in many ways I've agreed with the court's manner in which you've proceeded in these cases. In some ways I've disagreed in terms of the procedure. One of the concerns I have is that the state is now piggybacking a motion to stay on the day of hearing, today's hearing, on top of their motion and their non-objection to the motion to continue. The first time I hear this stay is today. Now, procedurally, it's not appropriate to even consider this. There was no motion filed by the state. They didn't put me on notice that they were going to argue this today. They didn't give me any indication until just 10 minutes ago that they were going to consider a motion to stay. Now, one of the other concerns I have is this, is that throughout these proceedings, Ms. Vallow's case was stayed originally because allegedly she had some mental health issues. And now allegedly she supposedly has some mental health issues as well. The court didn't stay the case previously and allowed the discovery and all of the motions to go forward. And at this point, to suggest that we're going to stay these proceedings and impose on Mr. Daybell the burden of not being able to effectively defend this case and do all of the things that are necessary because this state wants a stay is highly inappropriate. If you enter a stay at this point, Judge, we're done. We're done today. There'll be no consideration of the grand jury. There'll be no consideration of the bill of particulars. There'll be no consideration of the motion to sever. And it's a clever tactic that they're trying to engage. And that clever tactic is that they're trying to beat around and stop me from effectively arguing the motion to sever. The problem is they didn't follow the proper procedure. They didn't file a motion to do that, and I object first on that basis. The second reason I object is that from the beginning of the start of this case, every time there was an issue or a hearing or a status conference or a meeting or a conference with those folks and those two lawyers, I wasn't allowed nor was I able to participate in any of those. That was held separately from Mr. Daybell's case. I am completely...
What are you talking about, Mr. Pryor? Are you talking about meetings that have been...
I'm talking about the mental health meetings, Judge. I'm talking about evaluations. I'm talking about things that affected Ms. Daybell's, or Ms. Vallow's mental health and matters that pertain to her case. I wasn't allowed to participate. Now, I would think, I've only been doing this for 26, 27 years, but I would think that I'd be permitted to have access to whether or not Ms. Vallow truly is mentally unfit or whether she's malingering. But I don't have any idea. And the court's going to put a stay on me by keeping me in the dark from everything else and then imposing on the burden of me of having to prepare for this case because potentially she has a problem. So, Judge, I object on that basis, and I object that I haven't been noticed in this particular case. I object because I have not been afforded the opportunity to actively participate in anything as it relates to those matters with Ms. Vallow.
All right. Well, the court has considered the state's motion to stay. I do agree with Mr. Pryor. It's to the extent brought as a separate motion, not timely or noticed. However, the court is prepared to make a substantive ruling on it because it's important, I think, to just clear that argument out of the way. The court has entered an order previously in this case and been very clear that there are two separate cases that would be joined together for purposes of trial because the defendants were both charged together in a single indictment. And under the rules, that allows for one trial. However, the court has clarified over and over its position that there are two separate cases, two separate defendants, and those cases are separate other than for purposes of trial or for joint pretrial motions that for efficiency purposes, affect both cases. The stay in the other case, which is CR 2221-1624, is a stay that is, I would like that phone confiscated right now. Thank you, Mr. Bailiff. And I'll reiterate to the rest of the audience the court's order, which I went through expressly this morning, to please silence all devices. All right, as I was saying, in the companion case of 1624, the Lori Vallow Daybell case, a stay was imposed pursuant to statute, Idaho Code 18211 and 212. At this point, required a stay to be issued because the court received notice that her competency again has been called into question by a qualified psychologist who's issued a detailed report which rises to the level where the court has no option other than to hold a hearing to determine whether or not competency is currently sufficient for her to proceed in her trial. That's why that case has stayed. This case, Mr. Daybell has no issues related to 18211 and 212 that would allow for a stay. The case is not stayed. It moves forward. And for that reason, the motion to impose a stay in this case is denied, and this case will procedurally move forward. Otherwise, we'd have a situation where one defendant potentially just gets drug on indefinitely, possibly, waiting for someone else to be competent enough to stand trial, and clearly that would violate the constitutional rights that someone has, whether they've waived speedy trial or not, to have their case proceed forward. So there's not a stay effective in this case, and for those reasons, we'll go forward now on the motion to continue the trial and the substance of the motion. So I would ask the clerk to make a note that we'll enter an order that this request for a stay has been denied on the record today for the reasons I've stated. At this time then, Mr. Pryor, if you'd like to present argument in support of your motion to continue the trial, we'll take that up next.
Judge, again, can I approach the line?
You may.
Judge, I would like to inquire if it's still the state's position that they're going to agree to continue the trial.
I think our position is clear in the response that was filed. It noted that the request was that both matters be stayed, and that in effect was a continuance that was filed a week ago. So I don't think that position, I think that position has been consistent along with prior positions the state has taken.
Then, Judge, in that case, I'll, to everybody's delight, I'll shorten my argument a little bit so that we don't have to be here all day. Judge, I laid out in quite specific detail my motion to continue. I discussed the fact that I have a mitigation specialist who I've been in frequent contact with. Because this is a death penalty case, that mitigation specialist is an absolutely necessary. They didn't anticipate the magnitude of the discovery. Mr. Archibald had said something about 5 terabytes of information. I think I'm at 2 or 3 terabytes. Is what I have, but in any event, Judge, there is still a bit of outstanding discovery that I still need to address. There are going to be other motions that need to be addressed.
All right, Mr. Pryor, let me start on the discovery issue. We are supposed to be starting trial in January. I have not seen any kind of a motion to compel or any indication that you've been trying to get discovery that has not been timely provided. So if that's a basis for a motion to continue a trial, why haven't you filed any kind of a motion to compel with the court?
And Judge, without being in violation of the court's order, can I approach the bench with counsel?
Well, I guess to keep things moving, we can do that. I still need that on the record. If we want to do that, we'll need to have the court reporter come into chambers, and you can make representations there with the record being made through the court reporter.
Okay.
Okay, let's go ahead and do that then. We will need to take necessarily a recess to discuss that matter, and I'll need to allow time for a moment for Mr. Fuller to set up the stenographic equipment so we can record the conversation in chambers. All right. Mr. Fuller, are you ready? Thank you. We're back on the record on KCR 2220-11623, State versus Chad Daybell. We took a brief recess to discuss issues related to discovery that relate to the motion to continue. Mr. Pryor, and we put those on the record, I'll note, in chambers. Mr. Pryor, if you'd like to continue with your argument on your motion to continue, you may.
And Judge, just to conclude, I would say that because of the stay on Ms. Vallo's case, what was discussed in chambers that I'm asked to have incorporated into this argument, and the fact that my mitigation specialist needs significant amount of time to adequately prepare, if necessary, a report, I would respectfully ask the court to continue this matter.
All right, Mr. Pryor, before you take your seat there, I do have a couple of questions for you. First, and then I'll hear from the state's response, but I just want to ask you a few things in regards to your motion. This case, as everyone's aware, has been transferred for trial to Ada County. Everyone's also aware that the court's already made significant steps, time and resources to arrange for the accommodation of that trial with Ada County to start in January. Met with counsel there multiple times. The court's been there multiple times in preparation. And in terms of whether or not this is granted, I guess first I'd like to go back to the hearing we had, I think it was over a year ago possibly, where we discussed the trial setting dates. And you indicated at that time, Mr. Pryor, that you wanted the trial to commence as we are now in the fall of 2022, October. Said you'd be ready by then. The state wanted to wait out until summer of 2023. The court thought that seemed longer than necessary. After hearing everyone's arguments on when would be an appropriate time, the court determined this January 2023 trial date. And as I've read through your motion, and it's lengthy and cites a lot of issues going on there, but I guess the question I have is two questions. Number one, it appears you may have completely underestimated the time and preparation it would take to be prepared, because you said you'd be ready to go now. And we've got that on the record, obviously, and that was taken into consideration by the court when I set trial. Number two, if this is continued, I just want you and the state to both know that we can't just show up in Ada County when we want to. We have to show up in Ada County when they're able to accommodate this major case, because they have a lot going on in their courthouse and they've been very good to work with. But looking at their possibilities of when this could take place, it's not good news. It's not going to be necessarily summer of next year. It may not even be able to be fall of next year. It may take another year until Ada County is able to have this trial held there. And at some point, I can interject my own authority to make the trial happen when it needs to happen, but I also have to take those things into consideration. Your client's in custody, and is he aware of the potential very lengthy delay that this may cause in the case through those administrative actions that we would have to take to reschedule now this entire trial? So if you would answer those two questions, please.
Judge, and I'll start with your first question. In terms of underestimating whether or not I could be prepared, it's very clear, Judge, if the court doesn't continue this matter, I'm ready to start January 9th, okay? And I'll be prepared to start January 9th. There'll be a potential problem with what we just discussed in chambers, and that wasn't something that I had the availability of information regarding what we discussed in chambers. That wasn't something that I was contemplating was going to occur. That was out of my control. That was the state's pursuit.
And in general terms, you're referring to the development of the evidence in the case. Is that what you're referring to?
The development of what?
The evidence in the case.
That's what I would refer to, Judge.
Okay.
And that additional development of evidence caused me to have to take some additional steps. Those additional steps put me in a position where I had to decide whether or not I needed that evidence, that particular information. I need that particular information, and in the event it's not provided, it potentially could cause issues down the road for all of us in terms of other issues in other courts. So it was not a matter of not being prepared. And again, Judge, if you want to go forward in January, I'll be happy to start in January. It'll be a severed trial because I guess I don't know that because I don't know what's going to happen with Ms. Vallow. And frankly, if it's just Mr. Daybell and I and them, that's fine. We can go in January, but frankly, I would like all of the information, and I'd like to have everything, and I'd like to have my mitigation specialist 100% prepared. So, one, it's not a matter of preparation. That's ready to go if this court decides that's the case. In terms of Mr. Daybell and I, and I don't know, I want you to shake your head, but Mr. Daybell and I have had a half a dozen discussions about the discovery in this case. Mr. Daybell and I have gone over every inch of the discovery in this case and have discussed every aspect of this, and he's in agreement that it would be a good idea to set this out so that we can be provided all of the information that we need to go forward. And he recognizes that this thing may take a considerable longer time, and he's agreeable to do that. And I've spoke to him, Chad, a number of times on that, and he's prepared to and authorized me to file this motion to continue, Judge. So we're ready to go.
All right. Thank you, Mr. Pryor. Ms. Rawlings, response from the state.
Your Honor, I guess I would just reference our response and note that we are not objecting to Defendant Daybell's request for a continuance so long as it remains set with the co-defendant's case for a joint trial. As the court has stated, we recognize the court's administrative concerns. However, we do think that to avoid potential appellate issues and to allow the parties additional time to deal with pending matters, including the discovery discussed in chambers and concerns with the co-defendant's case, that it would be appropriate to continue the trial date. We would request a scheduling conference in January, and we would request that Ms. Vallow Daybell's attorneys be allowed to at least participate in some formal or informal hearing regarding that. And then we would just also ask the court, as the court noted, this has been changed for venue, and in our response we had noted that if the trial date was continued and split between or started in fall of 2023, there is potential cost savings for the counties involved by splitting it across fiscal years. And that also is in line with the concerns from the state in terms of having a joint trial and the expense associated with that.
Ms. Rawlings, as it relates to evidence in the case, is it correct that there is still evidence the state would intend to use at trial that has not yet been disclosed to the defense?
As the court's scheduling order notes, the discovery deadline currently is November 22nd, I believe. There are, I think, all the discovery that the state currently has in its possession has been provided to defense. There was a pending motion to allow DNA testing that would consume consumptive DNA testing, and I think the state had filed that. I want to say it was in the spring of 2021, and it stayed pending there for a while. And as mentioned, the parties did reach a stipulation regarding that, and so there are some items that, because of the nature of forensic testing and stuff, that are outstanding that neither party has at this time.
So to summarize, there is still some outstanding evidence, and I'm just thinking of the time frame because obviously a defendant would need adequate time to receive the evidence, review the evidence, and prepare for the evidence. And I don't know the nature of the evidence, and we don't need to discuss that, but if it involves any type of expert opinion, then clearly that presents a time frame issue as well. And Mr. Pryor's indicated he certainly wants to have more time to go through that, prepare for trial, but has also indicated on the record he can be prepared and ready to go to trial in January. In terms of the state's evidence here, I guess that's what I'm trying to pin down, is whether or not there's adequate time for the conclusion of the development of your evidence, the disclosure of that to the defendant, and allowing them time to review the evidence to be adequately prepared for trial.
I guess I'll respond to the court's inquiry this way. The state is prepared to go forward with trial in January as well. And if there is some evidence or information that has not been completed at that time, it will not be utilized, in essence.
Okay. All right, Mr. Pryor, do you want to make any additional final argument before the matter is submitted?
May I do it from here, Judge?
You may.
Judge, it's not a question of whether the state intends to utilize it. That's one of the concerns. I could care less whether they intend to utilize it. Whatever it is, I'm probably going to utilize it. And I want the information, and I'm entitled to it. If the state if there's any expert evidence or any forensic evidence or anything such as that, I'm entitled to it. And to suggest that in October, with the trial starting in less than or a little more than 2 months, there's not going to be enough time, sufficient time for me to get that, and I don't know when I'm going to get it. I know, for an example, I got their motion to object to my severance motion last night. So, if they drop it on me on the deadline of the discovery on the 22nd of November, I'm going to have a very difficult time finding an expert to evaluate that and even someone to look at it. So it's in there's a little bit of a precarious situation here, Judge, and quite frankly, if there is evidence out there, I'm the one who gets to decide whether I want to use it or not them. It's my case and Mr. Daybell's case. So if there's evidence out there, I get to make my own independent evaluation. They don't get to decide whether they want to provide it to me or whether they don't want to use it. That's not the way this works. It's a level playing field. I still get the information, and I want the information.
All right, counsel, I'm going to take the matter under advisement, and I would request that if the parties have any further written argument to submit as it relates to evidence in the case, that you do that by the end of next week, which would be 8 days from now. I think that's probably the 21st. To the extent that it involves disclosure of evidence that shouldn't be in the public record for some reason, you can notify the court of that prior to filing it, and we determine whether or not that gets filed openly in the case. So the court is going to take that under advisement. As I've mentioned, I guess a few things. First of all, it is a 2021 case, and in terms of a capital case involving all the charges it has with co-defendants, the court doesn't see it as a particularly old case. However, the case had preceding cases where both defendants were incarcerated and have remained incarcerated, and that's the time frame that's concerning me, is the length of delay in getting these cases to trial with incarcerated defendants, obviously, not to mention the substantial time and effort that's already been made arranging the trial when we've got it. However, the court also understands that the parties should be allowed to present all evidence that's available, either on behalf of the state or the defense or both. And so I'm a little unclear on how critical this evidence is when it may be submitted. So I just ask from both sides if you'd submit anything further revealing what you think these evidentiary problems and issues are in a time frame, then the court will make a final determination as to whether or not I feel like it would be fair and just for the trial to proceed on the date scheduled. So that issue will be under advisement at this time. Any questions on that, Mr. Pryor?
No, Your Honor. Thank you.
Ms. Rawlings, any questions?
I don't have a question on that. I do have an inquiry regarding, I think, the juror questionnaire that was due tomorrow.
Yes. We're going to need to bump that time frame out because this is under advisement, and I don't want you doing that unnecessary work if the matter is going to be continued. So I will get a decision out prior to the following week, the 28th. So for now, consider that deadline to be not in effect until such time as the court issues a decision on the continuance of the trial.
Thank you, Your Honor.
All right, and thanks for bringing up that point, Ms. Rawlings, as well. All right, that'll conclude the motion to continue the trial then. Let's next call up the motion filed for grand jury transcripts. September 28th, the defendant filed a motion for a grand jury transcript. The state filed its response on October 6th. We also, I will note on the record, discussed in chambers that this particular issue tends to, well, has a potential to go into closed or sealed matters as they relate to a grand jury proceeding. And so I think before the court is a purely legal argument that does not require divulging any sealed information from a grand jury proceeding, and I think it can be argued and determined without reference to that. But as I indicated previously, I would admonish counsel to refrain from disclosing any unauthorized information relating to grand jury in the argument. If there is a mention of that, then I would ask for a timely objection, and if necessary, we can again take up matters in chambers if the court has to discuss or hear argument on the merits or any factual specifics of a grand jury proceeding. So with that in mind, Mr. Pryor, if you'd like to present argument in support of your motion for grand jury transcript. Yes.
Judge, as the court noted, I filed my motion for grand jury transcript on the 28th of September. Judge, I reviewed the state's response. They discussed and went into the discussion about motions to dismiss, 12B motions, and as it applies in that respect, I am not trying to mislead the court or mislead the state. My request, Judge, is that I received information through part of the investigation of this case that there may have been a grand jury proceeding. I do not have specific information or any information as to what was offered as testimony in that proceeding, and that's appropriate. The rule clearly does not allow people who participate in those proceedings to offer what was said. It's a secret proceeding. What I do have, Judge, is have information that would suggest that potential witnesses in this case offered testimony as it relates to this case. Information and evidence as it relates to Mr. Daybell's case. So this isn't a motion for a request for a grand jury transcript in the way that I would then file a motion to dismiss the indictment or anything like that. What it is, Judge, is it's framed in the way that if there was information that was offered as evidence and it related in any way to Mr. Daybell's case, in any manner, in any way relevant, any factors that were discussed as part of Mr. Daybell's case, or any witnesses who've put forward any kind of testimony of any kind, the rules of discovery allow me to have that information, and I'm entitled to that information. And the state cannot keep that information from me. It doesn't work two ways, and this seems to be a recurring theme. They don't get to decide what information I get. They don't get to decide what evidence I get. The suggestion by Ms. Stallings, and I don't want to put her on the spot, but to suggest, well, we may not even use the evidence. Well, I don't care if they don't use the evidence. I may. I don't know what happened in front of the grand jury, Judge. I do have information that there was a proceeding. Mr. Wood has been kind enough to acknowledge that there was a proceeding. I don't know the judge. I don't know who was there. I have an inkling who was there. I have information that suggests who was there. And I have an inkling to believe that there was evidence offered as it relates to this case. This prosecutor is under an ethical obligation to provide me that information. The discovery rules require them to turn over any information of witnesses as it relates to this case.
And if they comply with those rules, what would be the purpose in you needing the transcript of the grand jury then?
Because I'm entitled to verification. I'm not going to accept their word. I mean, if they want to tell me, oh, don't worry about it, John, you don't get the information. I'm not doing that. They're going to provide me. Let me make my own assessment as to whether I need the information. They don't get to determine what's relevant. We've seen an example of that just a few minutes ago where Ms. Stalling says, well, we're not going to use the information. That's not their decision.
Well, I understand the point on that, Mr. Pryor, but I guess the issue here is there's clearly a rule under Idaho Criminal Rule 6.3 about the secrecy and confidentiality of grand jury proceedings.
Right.
So I don't see an exception in there unless requested in discovery. Discovery rules do govern what prosecutors have to turn over. And as long as they have complied with your discovery requests, is there any need for you to have this transcript? It would run afoul of a very clear rule saying you don't get to see that.
I got the transcript in the first grand jury proceeding.
Understood. That's because an indictment was returned charging your client, so clearly you get that.
Right. There's also rules that allow me to be provided any statements that the prosecutor has knowledge of that may relate to witnesses in this case and evidence in this case. And I have a right to be able to present evidence. And Judge, it's not a state rule that's applied here. I have a United States constitutional right that trumps everything they say, that this state needs to provide me a fair opportunity to present any evidence that I feel is relevant in this case, subject to this court limiting that by way of a 404B or other motion. But I am still entitled to the right to that information. And I don't have to rely on their representations that don't worry about it, it's nothing that's important to you. They don't get to make that choice. I get the information. They turn it over, and that's the way it is. This isn't, I understand there's grand jury proceedings and there's safeguards. This court can order the transcript. This court can review the transcript, and if necessary, hold a sealed hearing, providing both of us with an opportunity to review it. And if I feel it's something that is necessary, we can pursue from there. But to suggest that, they get a unilateral decision to limit what access to information I have in defending what is the most serious charge a defendant can face is absolutely ridiculous. And for them to suggest I don't get this information is ridiculous. And they are under an obligation to provide me that information.
All right. Response from the state.
Thank you, Your Honor. I would just quickly note that Ms. Rawlings never said that we get to decide what the defendant gets. She never said that.
I agree with
Her response was to a question from the court about whether or not we had turned over everything we were planning on using. We fully understand and have complied with our discovery obligations, and any assertions otherwise are blatantly false. In terms of this grand jury transcript, the state's objection is primarily procedural, Your Honor. In terms of what was discussed there, honestly, it really doesn't matter to us if Mr. Pryor has it or not. However, the question the state has is, does the law allow us to turn it over or allow for that transcript to be made? At this time, there is no such transcript that the state is aware of because no order has ever been in place for that transcript to be prepared. The state would note under Idaho Criminal Rule 6.2, transcript of grand jury proceedings, subsection C, there is a list of people who must be provided a copy of a transcript if they move so. That's the prosecuting attorney, a person charged in an indictment, or the person for the person charged, or an attorney for the person charged, or a person charged with perjury because of the person's testimony before the grand jury. Those are the only people who must be allowed. Now, I want to be clear, I think there's a little bit of ambiguity in these rules because it doesn't say someone else can't receive it. However, when you go into Rule 6.3, it's very, very clear that the proceedings of a grand jury are, the word they use is secret. And that nobody involved in the grand jury can disclose it. Under subsection C of 6.3, the very last sentence, no other person present in a grand jury proceeding may disclose to any other person what was said or done in the proceeding except by order of any court for good cause shown. And I would note that subsection C tends to deal with the members of the grand jury. So I don't know if that applies to everyone in the grand jury. If this court orders that a transcript be prepared of that grand jury and turned over to the defense, okay. We would ask that according to 6.2C, the last paragraph, that there be a specific order on the conditions applied to that all the laws and rules applying to grand jury transcripts or proceedings still be followed. I would note, it's not in our, I would also note just quickly, the state never mentioned 12B in its response to this motion. That was brought up. We didn't mention that here. In doing a little bit of case law research, there's not a lot of case law on this subject. The state did find one case dealing with it from 2003, and I would note that was pre-2017 when the rule numbers changed. But it basically just details again what 6.2C says. At the time it was 6.3C, but just that it reads, in the event a trial court grants a request to distribute a copy of the grand jury proceedings to a person authorized in Rule 6.3C, again now that's 6.2, the trial court may place conditions upon the use, dissemination, or publication of such copy. Your Honor, the state has no desire to hide anything from the defense. That's not what our response is about. We simply want to comply with the law. As we understand the law, the people who get that transcript are the people listed in 6.2C. If the court sees that differently, that's completely in the discretion of the court. But again, I would note, nobody is trying to hide anything that the defendant is entitled to see.
All right. Thank you, Mr. Wood. All right, at the outset, the court would note that the motion is for a grand jury transcript, and I've listened to the arguments of counsel here. If this were a matter completely unrelated to the case, then I think clearly the rules would not allow for any such transcript because an indictment was not returned. There is, as Mr. Wood mentioned, some ambiguity in the rules that talks about who must be permitted to have access to the record of grand jury proceedings, but does not necessarily exclude that either, with a provision at the end that the judge may place conditions on the use, dissemination, or publication of the record of proceedings of the grand jury. Let me just ask you a very general question, Mr. Wood, as I'm making my determination here, because I know nothing about this proceeding. I was not involved in it in any way. Does this grand jury proceeding that took place that did not end up in an indictment being returned have any rational relationship to this case, Mr. Daybell's case.
Your Honor, until ordered to disclose by the court, I can't answer that. I would ask that to answer that we'd be allowed to go in chambers, because I do believe that is protected information under the rules. And upon receiving such order, I will happily answer that question.
Okay. Fair enough. I think we will discuss that issue then, so I can make a ruling, because I think that determines whether or not there's a basis for the request under the rules, which may permit it if there is some relationship, and it may result in any kind of discoverable material relating to this case. So because of the requirement under Rule 6.3 of the Idaho Criminal Rules that indicates grand jury proceedings are, as they call it, secret and confidential, the court is going to meet with counsel in chambers, again on the record with the court reporter, to discuss that narrow issue without going into the facts of that, but just to determine whether or not there's a relationship for me to consider. So we will take another recess and meet in chambers. All right, we're back on the record. Are you ready, Mr. Fuller? Thank you. KCR 2221-1623, State versus Chad Daybell. Before the court is a motion for grand jury transcript. Counsel's provided argument. On the motion, the court met with counsel in chambers on the record to discuss issues related to the grand jury proceedings, which are by Criminal Rule 6.3 to not be disclosed in open court. The court has reviewed in particular Rule 6.3c and did make an order in chambers finding good cause for disclosure of the proceedings limited to the defendant, and so the court will grant the motion allowing a grand jury transcript. Transcript will be prepared as it relates to a proceeding. The date and administrative number of the proceeding will be kept confidential, but will be disclosed such that the appropriate transcript is made available. And then further distribution or disclosure of that is also to be prohibited once it's been received by the defense, and may not be disclosed outside of the confines of Criminal Rule 6.2 and 6.3. So finally, the court will also order that be prepared at the defense expense based on the request being made by the defendant. So, Mr. Pryor, the court will prepare an order to that effect, allowing for the preparation and disclosure to you for the narrow purpose of reviewing it as it relates to your case here, and we'll grant the motion. All right, any questions on the court's order, Mr. Wood?
No, thank you.
All right, thank you. All right, the next matter the court has before it is a motion for bill of particulars. Ms. Smith, will you be presenting argument on behalf of the state in objection at this time?
Yes, Your Honor.
Okay. This is a motion filed by the defense. It was filed on September 28th. The defendant filed a motion for a bill of particulars. The state filed its response in objection. At this time, Mr. Pryor, if you'd like to present argument on that motion, you may. Yes.
Your Honor, as a brief, just to maintain the record, the state would object to hearing it this time simply because the co-defendant has an identical motion with some minor pronoun and name changes. It's the same motion, and the state's position is that that Ms. Vallow has a right to be heard, that the arguments here could affect her rights, and it sets the court and or the state up for inconsistent rulings. And I wanted to raise that now to preserve that objection for the record.
Okay, the court will overrule that objection. I do find that that other case is currently stayed and does not prohibit a taking of the matter before the court in this case, which is not currently stayed. So, Mr. Pryor, you can present argument at this time.
And Judge, for the record, I take great issue with the state trying to apply orders that are entered in motions that are heard in the other case and retroactively applied to my case. I think that's highly inappropriate, and I'll be addressing that at a later time in regards to some other issues. But in regards to this issue on the motion for bill of particulars, Judge, I need to point out to the court, I think everyone's well aware that there is no statutory authority for what I'm requesting. There is no court rule for what I'm requesting. There's a civil rule that allows for something called a motion for a more definite statement. Now, the only thing I can cite, Judge, for the authority to do this is an Idaho case, and I cited the Neal case. But again, this is up to the sound discretion of the court. And what the court's decision in this is going to be the final decision as it relates to this. What I'm asking, Judge, is simply this. I would like the court to go and review the indictment. I briefed this matter I submitted my motion for the bill of particulars, and I pointed out where the state has made general assertions in their indictment. Those assertions don't give any specific facts or instances. Now, it is general pleading, but they have to give me some sort of indication other than, well, based on circumstances or based on information that will be provided. That kind of stuff is not general pleading, Judge. And what I'm asking the court to do is to review the indictment, and I'm asking the court to at least have the state provide some information to suggest what this so-called information that they're relying on to support this thing. They did give a couple of instances where they mentioned some relating to the co-conspirator acts and things like that, but very few, if any, applied to Mr. Daybell. Most of the acts that were mentioned in the indictment were almost exclusively applying to Ms. Vallow. So at this point, I think I'm entitled to at least a little more specific general pleading. And the way to request that and the manner in which I request that, Judge, is in this bill of particulars. If the court decides that they've provided enough information, we're done. But frankly, I would like the court to make a fair assessment by reviewing the indictment and determining whether or not the state should give me at least a little bit more information. And frankly, in the motion for bill of particulars, I offered the court some request as to what kind of information I would like. So at this point, Judge, I will rest on that. But again, this is up again to the sound discretion of the court to decide this issue.
All right. Thank you, Mr. Pryor. Ms. Smith, what is the state's response?
Your Honor, I'm just going to supplement briefly our written response. Mr. Pryor is right. There is no authority for this court to order a bill of particulars, and for that reason, the state would ask you to deny it. The second piece, if the court somehow sees it as an attack on the clarity of the indictment, that's really a Rule 12 motion, and the defense is clearly untimely in that, and there's been no request for a finding of good cause. Even then, under Rule 12, there's no authority for a bill of particulars. The court does, if you see it as a Rule 12 or a challenge on the indictment that the court has the authority to look at, your authority would be to order an amended indictment. Even then, the state would say the defense hasn't requested that. It's not proper. There's no finding of good cause. And candidly, Your Honor, this is really a very creative advocacy effort on behalf of both defendants to try to get at the state's theory of the case. Their motions are replete with references to the volume of discovery and evidence against their client. They're right. But you cannot use a creative pleading to try to get the opposing party's trial strategy. You cannot use a creative pleading to try to get the state's outline. And the Idaho Supreme Court in State versus McKennon, and that's McKeehan, 91 Idaho 808, has specifically found that an information or a charging document must contain the essential facts, but the state is not required to disclose in that document the evidence it intends to rely on to prove its case. So while I applaud the creativity and level of advocacy for opposing counsel, there's no authority for the court to give them what they're asking for. And candidly, it circumvents Rule 16. If they ask for the same information for the court in terms of our trial strategy, what evidence we intend to use under Rule 16, the court would deny them. And so this is a way to work around the rules of discovery to try to get us to outline how we intend to charge. I come from a jurisdiction where bill of particulars are allowed, and they're typically about the indictments lacking clarity or subjecting somebody to double jeopardy. Idaho specifically left that out of their rules, and that's because in Idaho, the court has the rule and the power under Rule 12 to order the state to clarify its indictment, and Rule 7, I misspoke, I'm sorry, Your Honor, under Rule 7 to order the state to file an amended indictment to clarify its information, to deal with issues where perhaps the indictment should be or information should be dismissed. And so in Idaho, there is no authority to do this bill of particulars. If the court were to generously interpret over the state's objection, the defense's request is somehow a request for clarity on specific language in the indictment. There's only 4 complaints truly that they raise that were this in a jurisdiction I practice that the court would look at, and that's their complaint about not naming every co-conspirator, charging a particular date range, using the word elsewhere in Idaho, the phrase elsewhere in Idaho, and the phrase concerned. And so each of those are governed by specific different principles in Idaho. There is no requirement in Idaho that the state identify every specific co-conspirator. That does not exist. And in fact, in State versus Yang, and that's Y-A-N-G, 167 Idaho 944, the court specifically says it does not require the state. And then another way of looking at requests for bills of a particular or for specificity is I often go then turn and look at the jury instructions. What are the jury instructions? What paper goes to the jury? What does that have to contain? And does the indictment put the defense on notice on what that document will look at? Even the jury instructions under your Idaho jury instruction 1103 and 1104, none of them even require listing of who the co-conspirators are. And so the defense is asking for things that are not required under the rules, not required under Idaho statute, and won't even go to the jury. And so there is no basis for finding that the state has to list every possible conspirator. And realistically, it's a very creative effort to get our theory on the case. It also fails to recognize and identify the nature of a conspiracy. There are often conspiracies where you will never know everyone who participated. And so to ask the state to, in opposite of case law, to identify everybody who could have participated in this conspiracy sets the state up for an impossible task and one that is not allowed for or required by statute. Turning next to the date range, that's controlled by 19-1414. Precise time at which the offense was committed need not be stated, but it may be alleged to have been committed at any time before the finding of the indictment, except where time is a material ingredient. Again, Idaho Supreme Court State versus Owens, 101 Idaho 632 in 1979 specifically said time doesn't need to be precise where time is not a material element. A conspiracy and or murder, time is not of the element. It's not included in the jury instructions that are submitted. It's also not a situation where someone faces double jeopardy. So it is typically required for specificity of time in situations where time, it must be proven beyond a reasonable doubt. For example, a reckless homicide where a parent knows their child is sick, needs their medicine, and fails to give it within a requisite amount of time. Time would be a necessary element. In this case, having a specific date and time is impossible. It's an ongoing conspiracy amongst multiple people who set out to kill and steal money from and retain money from people over several months and over 18 months of a period of time. Those items are outlined in the indictment. Specific overt acts are identified. And Mr. Pryor fails to outline for the court that nothing in Idaho law requires that every overt act be done by the defendant. The state simply has to show a defendant joined the plan, took a step in furtherance, and that one or more of his co-conspirators acted in furtherance and committed certain overt acts. And so asking the court to give you this is really a creative way to get the state's trial strategy and is not supported by Idaho law. The third area that if the court were to look at the actual language, the intent of Rule 12 or in other places of Bill of Particulars, the elsewhere in Idaho language, that again is controlled under Idaho Code 19-301 through 305. If anything, our indictment states too much. An indictment requires that an action occurred in the state of Idaho and specifically at least some part of it occurred in Fremont County, which is where this court is, and or a neighboring county. The state erred on listing 2 or 3 counties simply to put the defense on notice on, hey, multiple places have jurisdiction, but we're bringing it here in Fremont. I find it interesting that they're complaining we gave them too much information in a charging document through a motion that simply says is about lack of clarity. In fact, State versus Doyle, which is an Idaho Supreme Court case, specifically found jurisdiction exists if any essential element happens in the state. State versus Baker, another Idaho Supreme Court case from 2014, specifically found that precise location need not be proven or alleged as long as it's within the state of Idaho. So the request fails as to Idaho law as to the elsewhere in Idaho. And the third is questioning the phrase concerned in counts 2 and counts 4. Well, again, controlled by Idaho law 19-1416, the court is to look at the plain meaning of words in indictments the state uses. The plain meaning of the word concerned is involved. A quick look at a thesaurus tells you that. And so there is no legal basis to ask the state to change a phrase which has plain common knowledge, plain meaning, and does not require specificity. I think the state's position remains, we're asking you to deny it and to deny the creative effort to get our work product. We're also asking you to take a bit further. There's been a series, and this was in our request and on our conclusion, we made a specific request in your findings that the court begin to put some structure to some of these 12B motions. We understand and appreciate the zeal with which defense counsel is addressing these, but at some point, Idaho rules and timelines have to mean something. To serve a long pleading on opposing counsel at 5 o'clock at night, 14 days before the hearing, sets everybody up for problems. And so we would ask you, as part of your denial on this, to begin to put some structure to these, what should be 12B motions, because at some point we have to kind of quit nitpicking about the legal documents and focus on the facts. I recognize they have a lot of discovery, and I recognize the evidence on this case is overwhelming, but their effort to creatively get our work product has to fail.
All right, thank you, Ms. Smith. Mr. Pryor, would you like any rebuttal argument?
Judge, I find it amusing that the state is complaining about me providing them a brief 14 days before a hearing, and I understand that it was a significant brief. It took a significant amount of time for me to prepare it, but I find it almost comical that they assert that, and then yet at 2 o'clock or 3 o'clock yesterday, they finally, after 17 days, get around to providing me a response on the motion to sever. So I agree with them that this court maybe should set some court rules and guidelines regarding further motions. Judge, I think they're misunderstanding this. At no point is this bill of particulars a 12B motion. I filed a 12B motion to dismiss. This court denied that motion and said, no, it's sufficient in terms of in that regard. What this bill of particulars is, and Judge, there's no authority that prevents me from seeking this bill of particulars. I agree with the state. There is no authority that says, yes, you can, you should do this or have to do this. There's no state rule, there's no court rule, there's no, there is a case law that allows for this to go forward. And if the court denies it, that's fine. What I'm asking, however, is the court to take a look at the indictment and determine whether or not this court feels that the way they phrase things in that indictment is enough to put me on notice as to where they intend to go. And my perception is they have not. My perception is that the long range of when they are claiming this alleged murder to have taken place, it's a huge gap. They do have to at least give me some indication of who these co-conspirators that they're claiming are out there. They have to at least give me some notice of what they're claiming. I'm not asking for the theory of their case. In no way. I already know what the theory of their case is. But they do have to at least put me on notice regarding basic information. And it's not one of these things where they have to divulge work product or anything like that. She's misconstruing what this is concerning. They do have to provide me with the proper notice of exactly what they're claiming took place here. And it can't be something as such as, this was a murder, figure it out, Mr. Pryor. And quite frankly, that's what it looks like to me in the indictment.
All right, thank you, Mr. Pryor. The court's considered this motion for a bill of particulars and I'm prepared to make a ruling from the bench on that at this time. And as it relates to the motion, as has been pointed out by counsel and the court agrees, this is a discretionary decision with the court. There's no specific rule or statute governing a bill of particulars in Idaho. Idaho has adopted criminal rules implemented in 1980. The current version of most of the rules. The state has cited in its response a State versus Holcomb case, which is one case that states that any Idaho case suggesting a court-ordered bill of particulars was permissible predates the adoption of the Idaho criminal rules. Idaho Criminal Rule 7 would govern the requirements for an indictment, and the court has reviewed this indictment previously on several occasions, including ruling on substantive motions that relate directly to the indictment, including a motion to clarify or amend the indictment, which not too long ago the court went through the indictment in a lot of detail to rule on that motion, ultimately denying that motion and finding the indictment sufficed under the standard brought at that time. As it relates to the bill of particulars then, the court does find that without authority for granting of that, without that bill of particulars being included under Idaho criminal rules, and that it's expressly been, well, it's been exempted out of Criminal Rule 7, that there is not a ground or basis for the granting of the motion. The court does find that the indictment complies with Rule 7 in terms of the language within the indictment and incorporating the findings I made previously also on the ruling as it relates to the motion to clarify or amend the indictment. I incorporate that finding as well in the decision here today. So in my discretion then, Mr. Pryor, I'm denying your request under the motion for a bill of particulars, and that will be the ruling on the motion. There was a subsequent request by the state and some indication from counsel of a frustration over scheduling of things. The court will not make any formal ruling today, but will consider whether or not a subsequent pretrial order that governs pretrial procedures for filing and hearing motions before trial needs to be implemented in this case to prevent last-minute filings, which unfortunately aren't really clearly covered by the criminal rules, which I was just referring to. So if I think that needs to be entered into the case to facilitate responses of pleadings and getting them heard, I'll consider that and set forth some timeframes that may be ordered. So that part will be taken under advisement. So that will be my ruling on the motion for this morning. Mr. Pryor, do you have any questions on the ruling on your motion for bill of particulars?
No, Your Honor. Thank you for your consideration.
Thank you. Ms. Smith, any questions on that ruling?
No, Judge, thank you.
Very well. The next motion that was filed and scheduled for today is a motion to sever. The court will note that came up on the record in chambers, and the court was advised that perhaps the parties believe this may be best suited for hearing another day. Mr. Pryor, on your motion to sever, which was filed September 27th, it's been scheduled today. As you've noted, and I did too, extensive brief was received yesterday, an objection as a supplemental brief. There was a first initial objection also, but are you wanting to go forward on your motion to sever today, or would you request that be heard another time?
Judge, I'm going to request that to be heard another time. Judge, I'm not going to assert, and I don't want to misrepresent, but I may file a response to that. I reviewed it last night, and then I took the liberty of reviewing again this morning, and I haven't been able to make a decision as to whether I need to file a response. So I am asking to set it over. There is a chance a response will be filed, but I don't want the court to, I guess I'm not asserting that I'm absolutely going to file a response, but I want to at least have an amount of time to consider whether I want to do that. So I would respectfully ask to set this over a bit of time to have that brought up.
All right. Do we have a hearing date for November? What date? 10th? I believe we've got motions scheduled to be heard on November 10th. Well, let me first ask and confer with the state there. This was scheduled to be heard today. Does the state have any objection to continuing the motion to sever?
No, Your Honor, the state does not have an objection. And I would note, we recognize that our brief was just filed yesterday, and we anticipated that there was a chance Mr. Pryor may want some additional time. As the court's already noted, we've requested that we get some kind of an order on these filings. Generally speaking, a filing made 16 days in advance of a hearing would be sufficient. In this case, there was a 31-page brief filed by defense citing over 30-plus cases. All the prosecutors on this case also work other caseloads, so we do our best to try to get timely responses in, but it essentially allotted us 7 days to get a response in timely, and that simply wasn't enough time to review all the cases and put together our responsive brief, which I do recognize was 35 pages. So given all of that, the state agrees that if Mr. Pryor would like to file a responsive brief, he should be, or a reply brief, excuse me, he should be given an opportunity to do that. So we have no objection to a continuance.
All right, thank you, Ms. Blake. To be clear again, November 10th? Okay, we've set aside Thursday, November 10th. That'll be 4 weeks from today. I would assume that would be sufficient time for any further replies and preparation on that motion. Would the November 10th setting work for you, Mr. Pryor?
Yes, Judge, and that's at 9 o'clock, correct?
We will probably issue a notice of hearing once we figure out what else may be heard on that date to schedule times, but I would anticipate it would be in the morning.
Thank you, Your Honor.
Okay, we'll continue that till November 10th then. Mr. Pryor, did you have any other motions to be heard today?
Nothing further, Judge. Thank you.
All right. Anything further from the state this morning?
Nothing further, Your Honor. Thank you.
All right. Thanks for your attendance. Thank you, Mr. Reporter, as well. And we will be in recess.